Before we get started, I always like to do some introductions just in terms of who Cornerstone is. And for those of you who have joined our webinars in the past, you'll know that I go through these, but we might have some new folks who are not familiar with Cornerstone. And I feel that's important because there's a very good chance that you might have no idea who Cornerstone is because your advisor really doesn't brand themselves as such. To give you some idea of who we are, Cornerstone is a registered investment advisor based in St. Louis, Missouri. We were founded in 2005. We have about 123 advisors scattered over 16 different states. And even though the markets haven't been too cooperative lately, our AUM is actually around $6.5 billion. And we continue to grow very rapidly as advisors choose to join us coming over from other firms. As I mentioned before, you may have never heard of Cornerstone before because your advisor brands as Triada or LifeMap or Vine Wealth Management or Ginfinity. These are all some of the brands that our advisors choose to build on their own, which we fully support to allow them to really run their practice as they see fit. All of our advisors are affiliated with LPL Financial. LPL is the largest independent broker-dealer in the United States with over 20,000 financial advisors who work with them. They have 0 proprietary products and they have over $1 trillion in assets under management. And how this all comes together for you is really in 3 ways. First of all, your independent financial advisor is dedicated to making the right decisions for you without a home office or without a broker-dealer telling them what they have to do. They're independent so they can make choices on their own. But they, at the same time, need a broker-dealer that can custody the assets, provide products to fulfill your needs. And that's where LPL comes in. Where Cornerstone comes into the mix is we help them run their business more efficiently. We provide services, we provide structure, we provide support. And this webinar would be a great example of that. It allows the financial advisor really to focus their time on you as opposed to trying to plan some of these things on their own. So today we're very excited to have a topic that I think is very important to everyone. We're going to be talking about estate planning, and our guest speaker that we have is Scott Keifer. Scott is the founder and lead attorney of St. Louis Estate Planning, which is based in St. Louis, Missouri. Scott's worked with a number of clients of advisors with Cornerstone over the years. And as I see it, this is my opinion, but a big part of estate planning is doing a lot of preparation in advance to avoid any surprises for your loved ones down the road. And just to give you an idea of Scott's level of preparation to avoid any surprises, earlier this week, he reached out and said, you know what, we need to build in some redundancy. So if anything goes wrong with this webinar, we'll be backed up. Now, it's probably the 8th or 9th webinar we've done for clients, and we have never had a speaker ask for any sort of redundancies to be built in. So one option we came up with was maybe Scott could come to our offices and be in a separate office from me. If anything went wrong with his computer, he could run down to my office and start presenting from my screen. Another option was that he would stay in his office and he would have his paralegal Donna be logged in as a presenter. And if need be, he could run over to her office. So that's what we have today. That's what we chose. Scott is in his office. And so, Scott, now that I've completely jinxed your computer, why don't I turn things over to you and let you take it away?
Yeah, so there is a history there. I was doing a presentation one time and my computer decided to do an update and a reboot while it happened. And I had about 3 minutes of terror while I logged back into 100 people who were waiting for me. So, Bill, thank you for the introduction. I am really appreciative of everyone who joined today and your financial advisor for suggesting you join this. I'm actually going to share my screen and let me get that up there. Bill, I want you to make sure that we're doing good. Are we good there, Bill?
That's perfect, Scott.
Okay, fantastic. So I was told the other day that we could have as many as 370 people joining this, which is really quite a remarkable feat considering it is such a tough topic. Nobody wants to do this. And I know because I'm an estate planning attorney, all I do is estate planning. And I work with good families all the time. I promise you that although this topic is tough and you may want to join it, or want to ignore it, you've chosen to join and you are going to learn something here today. We're all grown-ups. We know early on that there will be an end for us, and we do a lot to try to ignore it. And you can't control it, but there are some things you can control. One of the things you can control is whether or not you give your loved ones a smooth handoff, no handoff, or something in the middle. Everyone is coming here today with a different level of preparation. Some of you are thinking, hey, I'm just going to listen, but all my estate planning documents are in order. I'm good to go. And some of you are thinking, we've done nothing on this for years. It's probably time. So let's listen and see what it is. Even if you come in thinking everything's in order, I'm going to tell you right now, there's a lot more that you need to be doing. There's a lot more you could do, which would make things easy for your family. There's a lot you can do, which is free. There's things you can do over time, over the next month, or 6 months, or a year. It will make all the difference for your family when you are gone, and they will greatly appreciate it. How do I know this? It's not because I've been an attorney for 25 years. It's not because all I do is estate planning for the last 8 years, and we've worked with 1,700 families in various situations. It's because a year ago, I had a brain tumor, and it was not looking good for me. And I spent 4 weeks preparing to die. And even though I had all of my affairs in order, even though everything was good from a legal standpoint, I had a lot to do. And I learned more in those 4 weeks, which I am thrilled that I can pass along to my clients and pass along to you today so that you're not in that situation. And so here's what we're going to cover today. We've got 4 topics. First, we're going to do estate taxes. Some states have estate taxes, but the federal government does have it too. Part 2 is going to be what we call planning for them. That is planning for the people you leave behind, wills and trusts. Ultimately, if you do a will or do a trust, it does not affect you because you're gone. You're doing this because you love the people you leave behind. You're planning for them. We're also going to go over some trust examples and kind of show you the way it works in real life. Number 3 is the planning for you. Planning for them is when you're gone. Planning for you is when you're alive, because we all need help as we age. We all need help if we have a car wreck and can't manage our affairs, or we have a stroke. Those are the documents that you need while you're alive: power of attorney and healthcare documents. Then we're going to wrap up the day today with going over what I learned in those 4 weeks that I don't know any other attorney who knows, because I haven't lived through it, and what I want you to know because it is just very helpful for you. Part 1, estate taxes. Often my clients come in and say, because we have a checklist. Does this concern you? Does this concern you? Does this concern you? And more often than not, people say estate taxes concern them. But the reality is it affects very few people. Less than 1 out of 1,000 people are impacted by estate taxes. If you have less than just short of $13 million, it doesn't impact you. That $12.9 million that you have to cross over before you pay any estate taxes increases every year by inflation. That's what the law is. So next year it might be 13.4 million you can pass along to your family before you get taxed. You do need to know that in 2026, this amount is set to be cut in half. But it's still a lot. It's still going to be, somewhere between 6.5 and 7 million that you can pass along. It'll go from affecting 1 in 1,000 people to affecting about 2 in 1,000 people. The tax rate you get charged is 40%. And that's not of the whole 13 million, it's the amount over. So if you have $1 million over that exemption amount, you'll be taxed at 400,000, which is a lot. It's just not a lot compared to the 13 million that you're passing along. So there are some things you can do to avoid estate taxes. If this is something which you're in that top 1.1% of people, married couples can double this amount. So a married couple can pass along 26 million. But you have to do something in order to be able to do that. When the first spouse dies, their survivor needs to notify the IRS through this form called Form 706. Hey, my spouse died. It is a free return to file, by the way. My spouse died and they didn't use any of their exemption amount, their 13 million in exemption amount. I sure would like to have that amount so that when I die, I get my spouse's 13 million exemption plus whatever the law is when they die. So if you have more than $1 million, file the form, because we don't know that the rule isn't going to be when you die that you can only pass 500,000 to the kids. So why wouldn't you take your deceased spouse's 13 million in exemption plus the 500,000 exemption you can get when you die? And so you'd be covered. There is a 9-month deadline after your spouse dies to file this. It's a really big deal. You should do it. It used to be a hard deadline. And if you went 9 months and a day, you were done. The IRS has backed off of that a little, and they now say you can do it up to 5 years after, but you have to ask for an extension. Don't ask for an extension, just get it done. The other thing is you can do is if you have any concern that this is going to be a problem for you down the road, there's other tactics you can do that are available. You just need to do it early. And when I say early, maybe 10 years before you're dead, because there's some crafty things attorneys can do to get some of this money away from you in a way that your family will not pay taxes on. So let's talk about states, because sometimes you live in a state where there are estate taxes also. Any of the pink states on here are states where they have estate taxes. The green states are states where they have inheritance taxes. The difference is really just a tiny one. Estate taxes are paid by the dead person's estate. Inheritance taxes are paid by the living people who inherited. Same thing. Money's being taken from a dead guy before it goes to the living people. The laws vary substantially. 32 states are not affected whatsoever, so we're really not going to spend much more time on this. You really could Google. You could Google estate taxes in my state, and within about 5 minutes, you can figure out most things you need to know and whether or not you need to talk to an accountant or a financial advisor. So to kind of summarize where we're at on estate taxes before we move on, there's 3 takeaways. Doesn't affect most people. File IRS Form 706 when the first spouse dies. And if you are affected, plan early. Go to part 2, planning for them. These are the ways that you can help your family out by making a smooth transition after you're gone. We've only have 2 options on this. It's wills and it's trusts. You are going to know more than most attorneys in the next 10 minutes about how wills and trusts work. When my clients are attorneys, they get done with this and they say, I didn't know that. And it's not that difficult. I'm going to use some drawings to make you think about the proper way to look at these documents. Next time you go to Home Depot and you see the broom and dustpan, you're going to think of me. Next time you go to Home Depot and see a Home Depot bucket, you're going to think of me. And here's why. Let's talk about wills. Clients often call and say, I need a will. Or they call and say, hey, I have a will, things are in order. Well, they're surprised when I say, well, you have a will, you have a broom and dustpan, you have a way to clean up your mess. Your goal is to not use a will, ever, because your will is nothing more than your instructions to a judge. Nobody wants to go in front of a judge. And that's what you've done when you use a will to transfer things to your family. It only works in probate court. It is slow and expensive, and expect 7 to 12 months. And that's if everyone gets along, 7 to 12 months to get assets to your family members. Once again, the will just cleans up your messes. Let's talk about how expensive it is. Most states say your attorney and your executor are entitled to reasonable fees for their pain in the rear end of dealing with your will, moving assets through. Missouri takes it a step further and says, hey, we'll tell you what reasonable fees are. And so it's set out in Missouri law. So down here is, on the left side, is how much is going through probate. Well, let's use a simple example that if you have a $500,000 house, and if you have not filed a transfer on death deed to your kids or to whoever you want to get the house when you're gone, and not many people do it, If you have not filed that deed while you are alive and you die and your will says, this goes to my kids, well, guess what? Your kids are going through court. They are taking the house through probate 7 to 12 months. And here's how much it's going to cost. Your personal representative, called your executor, is entitled to a fee of $14,000 for their inconvenience of dealing with this. Your attorney is entitled to a fee of $14,000. You're going to spend 28 grand. That's before court costs. And so you'll probably spend closer to $30,000 to move your $500,000 house to your kids. And it is a completely avoidable problem. So since we know you don't want to use a will, we have 3 options that we look at every asset you have, and we say we want to avoid probate. We want to avoid will. Number 1, it is putting someone else's name as a co-owner on your stuff. It is a frequent thing done by my widows who are in their 70s because the bank tells them to do it. It'll start with this. Oh, Hazel, I'm so sorry your husband passed away. Put your daughter on your account. She can write checks for you. It's a really good idea. Well, then Hazel comes and visits me and she says, oh, my daughter's on my account. It's great. If I die, it's her money. Yeah, well, guess what? If your daughter gets divorced, they take your money. If your daughter files bankruptcy because she got in a car wreck and hurt somebody, they take your money. Those are the ways that mom can lose her money by putting kids' names on it. Don't ever put your kids as a co-owner on your asset unless it's a small account, right? A $5,000 checking account. I've had people come in and they'll put their kids as co-owners on the house. If one of those kids gets divorced, that house is being sucked into their child's divorce situation. Number 2, our next option is a trust. I'm going to talk about a trust being like a orange Home Depot bucket. We're going to talk about that next. But before we do, let's go to what we do if you have a will-based plan. You have put transfer on death on everything you own, right? TOD, transfer on death. POD, pay on death. Beneficiary designations. 3 phrases, same thing. If you have everything you own with a transfer on death listing, everything goes to your family when you're gone, it works very well. This is your plan when you don't have a trust. This is your plan when you are using a will, because you don't want to use a will. You want to use transfer on death. The benefits of it, it's easy to do. It is basically free to do. You just go to the bank. You're just investing some time. You tell your financial advisor, hey, here's who I want to get my accounts. You can update it at any time. You don't need to pay an attorney. But here's the problem. It usually works fine. And I throw the word usually in here, and I've italicized it, I've underlined it, and I've highlighted it. Usually is not great. And let's go through how that can be a problem. People don't always die in the order you think they're going to die in. The natural order is grandma and grandpa pass away. Years later, the kids pass away. Years later, the grandkids pass away. And sometimes they die out of order. And grandma and grandpa set their kids up to inherit stuff. Well, maybe one of the kids is deceased and the grandkids are inheriting. Not great for an 8-year-old to inherit. The second thing that can happen is if you give your assets to your kids, maybe they shouldn't be inheriting those at that time. Maybe there's a divorce looming on the horizon and your money that you gave to them gets sucked into the divorce and they lose half of it. Maybe it's a minor. Maybe it's an irresponsible person. Once again, we're back to it usually works fine. And we don't tell people you can't do it. We just say you need to really pay attention. Let's go through a graphical example for anyone who likes pictures more than the words I put up. This person is using a will-based plan, and so they set up everything they own with transfer on deaths. They have a bank account, they have their house, they have their investments at Cornerstone, and they have their vehicles. Mom has 3 kids, and the arrows are the transfer on death listings that she has set up at her financial institutions. Once again, usually works well, but I'm going to screw this family up. A passes away before mom does. A's little kids inherited. B is in a bad marriage. In Missouri, if you inherit money and you leave it in your account, it's yours. But if you inherit real estate, it's yours and your spouse's. Nothing you can do about it. Your spouse has interest in that. And if your marriage stinks, well, you've just lost the house. Person C here has some problems, maybe gambling, maybe drugs, maybe alcohol, maybe they're just terrible with money. There's no restrictions that can be done when you put a transfer on death on them. And maybe that's okay. So people often ask, hey, I have my transfers on death set up. Why do I even need a will? It's a great question. And there's 3 reasons. Number 1, you need a will if you have minor kids, because it is the only document where you can tell the world, where you can tell a judge who raises your kids. I have 3 kids. There's nothing more important to me than making sure they land in a home, and people aren't going to argue over who gets them or who doesn't get them. You as a parent use a will to tell a judge who gets your kids. But even if all of your kids are grown, number 2 is a really big deal. Maybe we find out after you're gone that there's an asset without a beneficiary. Maybe you buy a new house. We're on the second one here, new assets. Maybe you buy a new house and you don't file a beneficiary deed, and then you pass away and your kids, they really need to go to court to get that. Well, we're up to number 3 here. Your will is your instructions to a judge, and it just makes things easier on your family because the judge knows who to trust. The judge knows who you trust. The judge knows a simplified manner can be used instead of a more complicated one. That's the benefit you give with a will. But you want to use TODs, but have the will as a backup. So here's our 3 takeaways on wills. A will means you're going to court. It cleans up messes, our broom and dustpan. You must ensure you have a transfer on death on everything, not most things, everything. If you have a bank account, you might also have a money market and a CD there. Sometimes we see mom has put a transfer on death on the bank account, but not the money market and not the CD. You don't want that to happen. With a will, you must stay diligent because people can die out of order and new assets do come into play. So now we're going to go on to our trust. And here's our Home Depot bucket. You will never see them the same again. And at every aisle in a Home Depot, they'll have a stack of buckets. And I hope you think, hey, those are trusts. So the trust collects, manages, and distributes your assets in the way you want. And we skip probate. Everything you have doesn't go to your kids, it goes to the bucket. The trust has rules that allow all kinds of contingency planning. Anything we can think of that could possibly happen, we plan for it in there. The people who set it up, that's you, called the grantors, you can always change the rules. Most trusts we write say that even if one spouse dies, a survivor can change the rules. Then there's the person who manages the bucket called the trustee. After the grantors are gone, a successor trustee will take over. They have to follow the terms. It's not optional. Mom and dad set up the bucket. Person A is in charge when mom and dad are gone. Person A has to follow the terms and do what it's supposed to do. The last thing on here is another big deal people don't think of. It's private. Anything going through your will is public record in most states. Anything going through your trust is private. No one has a right to know how much money you had, who it's going to, who you excluded. You'll see in the news, it'll be, oh, so-and-so famous person died and their will got filed and it's a public record. But really, it doesn't tell you anything because if they had everything in a trust, it could have been going in completely different terms. So we're going back to the same family that I messed up earlier, but we're going to throw a trust in the mix. You will see they have the same investments. They have the same arrows, which are the transfer on death listings on those investments. But now the arrows are heading into the bucket. It's our buffer. If A died, it's horrible, but we've planned for that. We've planned for any of these kids being gone when mom or dad pass away. We've put protections in for the grandkids. For instance, hey, A can take her money or his money. But if A is deceased, A's kids don't get the money outright. It can be used for college, maybe a down payment on a house, school, food, whatever they need, but an adult's in charge of it. And then when the grandchildren turn 28, they can take a third of their money, and maybe 32, a second third, and maybe 35, they can clear their bucket out. Those are the wonderful things. Person B here, who's not in a great marriage, has the ability to leave all their money in the bucket if the bucket's written right. I tell clients when mom or dad die, I say, I need to know how good your marriage is, and you need to be honest, because if it's anything other than perfect, leave your money in the bucket. It's protected from divorce and bankruptcy and all those things. Take 20 grand out for a new car. Take the money out for a trip. Leave the rest of the money in the bucket. It's a wonderful thing. Person C here has some problems, and we can manage how much money goes to C. We're now going to go through the trust in some real life situations. We got 5 or 6 that we'll hit here. The traditional family, right? The Leave It to Beaver family. First marriage, all joint kids. We've already hit this. Death in unexpected orders, protect inherited property. This third one is a really good one. Often we write it to say, hey, your kids are responsible, great human beings. Oh, yes, they are. They're wonderful. They're adults. Okay, well, we're going to write it up that mom and dad are in charge. And then when one parent dies, killing off dad again, we promote one of the trustworthy children to be a co-trustee, a co-manager with mom. When my dad died, I did that with my mom. She promoted me to a co-trustee. She can fire me. I cannot fire her. But she can manage her money, and so can I. And I don't, because she doesn't need me to. But as she ages, I am already empowered to do all those things without getting doctor involved, without getting legal documents updated. It's an I love you provision in there, and she knows that it's there. So that's the wonderful thing about trust, is we empower people to help as you age before you get older. Blended families. Everyone thinks of like the Brady Bunch, right? We all grew up on that in the 70s. I grew up on that in the 70s. Mixed families. Well, blended families are also seniors as they age. Maybe one spouse dies and they get married again, or they live together. Well, in blended families, you got to be real careful saying, when I die, everything goes to the kids. Well, maybe it's her kids. Maybe it's his kids. Maybe it's both of them. You always have a balance of concerns about, I love my new spouse, but I also have $1 million that I earned with my first wife of 40 years that really needs to go just to my kids when I'm gone. But you don't want your new spouse kicked out of the house. So we can write trusts that say, hey, if his money's his, her money's hers, but she maybe doesn't have enough. So if he dies, his money's kept in trust. She gets $50,000 a year, which is what the financial advisor can make on that. But then whenever she dies, the house goes to his side and the money goes to his side. And she can do that on her money too. Once again, bring an issue to the attorney will solve it, because we've done this over and over. The trust can control and restrict inheritance. I hit this earlier, but let's talk about incentive provisions here, right there. I had a client a few years ago who said, I've got a great kid, but man, when he gets money in his pocket, he doesn't want to work. So what can we do, Scott? So we put W-2 provisions in the trust. The dad funded, I think it was between $500,000 and $800,000 in that trust for the child. And each year the child will have to present a W-2 to the trustee. The trustee is LPL, and LPL will match out of the trust the next year how much the son made. So if the son didn't work, he doesn't get money out of the trust. If the son has a job where he makes $80,000, $80,000 comes out of the trust. It's really flexible. Special needs beneficiaries. Some people are better off not inheriting directly, because maybe they've got a pretty good, stable situation, maybe in a group home. If they are special needs, they like where they're at. And maybe if they inherit the money, they'll be kicked out of there because it's not a home for people who have their own money. So those are all things that need to be addressed too. Lots of other situations we'll hit quickly. Family farms, vacation property, small businesses, adult children who do not get along. And if someone has a long-term disease like dementia, which is a horrible disease, there's things that can be done to protect the money from being completely eaten up in the nursing home. So this is going to wrap up our trusts. Summarize it in 3 points. They can be very flexible. They can be very thorough. Our bucket can do anything you want. But my caution is they're not all treated equally, or not all created equally. We work between 8 and 10 new families a week. And you may go to someone who does bankruptcy, divorce, lawsuits, traffic tickets, and trust, and they do 3 a year. I would recommend you go to a specialist who can build in all the flexibility, because a lot of what we see is not that great. you should review its terms every 5 to 10 years. Maybe your situation and the buckets expectations have changed a little. And it does only work if everything is titled properly. Let's go to part 3. We are most of the way through. Part 3 takes not much time at all. This is what you need when you are alive and to empower your family to assist you. 2 documents. One is your financial power of attorney. That's who manages your money if you can't do so. And the second part is your health directive and living will. You figured out I like my drawings. I like my examples. A financial power of attorney is where you give someone else the power to be you and to act for you. I think of it like giving someone else a set of car keys and saying, hey, I need you to help me out. I need you to do this. They're driving the car for you. If you don't have one of these and you have a stroke before you put this in place and you're not going to die, your spouse is going to need to go to court. They're going to need to get a judge's approval to manage your money. Your spouse will have access to your joint money, but your retirement accounts are just yours. And a judge will oversee that for the rest of your life. And it is not a great situation. Your family will not be happy. The powers in a power of attorney are very broad. Anything you can do, almost, the law allows us to put in a power of attorney so your family can do for you. There are 2 types. One is called a springing power of attorney. It only springs into action when you are unable to manage your affairs. And that's what everyone thinks they want. Hey, as long as I can manage my stuff, I don't want anybody doing it. I want this to spring into effect. You don't want that. You want what's called an immediate power of attorney. And it seems stupid, but it's not. As soon as you sign it, your spouse has the power, or someone else has the power to be you. You can go on vacation to Florida and you come home and they sold your house and cleaned out your bank account. The reason you want that is because 1, you're never going to appoint someone who will do that. And 2, if you have a degenerative condition like Alzheimer's, they need to help you as your mental condition gets worse, but before you are fully incompetent. And we see it over and over. We only do the immediate powers of attorney. Healthcare documents. This is very simple. It's the easiest thing we do. The first part is durable power of attorney for healthcare. This is your list of agents. If I can't make a decision at the hospital, I want person A, then person B, then person C to do it. And then your second part is your healthcare directive, also called your living will. This is all the unpleasant decisions. If I'm persistently unconscious, I'm never going to wake up. If the doctors have tried everything, this is your instructions on the family on what to do. Often your agents on this are very different than the people who are good with your money. I don't know why, but women generally rise to the top. I assume you guys are better than we are at making the tough medical decisions, but my clients always mix, the boys or the girls, but when we get to healthcare, the girls almost always rise to the top of the list. So here's our 3 takeaway on the power of attorney in health. Financial power of attorney is critically important. Look at yours and see if you have one. Is it effective when you sign, or does it talk about doctor certifications? Healthcare documents remove the burden of the tough decisions for your family. When I talk to clients who had to make the tough call on their parents or someone else in the past, they often say, it was very helpful that my mom had done this because I could look at the document and follow what she wanted me to do. They feel like they're not making the decision. They feel like mom made that decision years ago. Both of these documents, power of attorney and healthcare, need to have a chain of command, not just one person. So don't say my spouse can do this, say my spouse, then person B, then person C, then person D, because you don't know who's going to die in what order. All right, we're near the end of this. This is where I would normally stop my presentation, but since everything a year ago, this is new. I'm hoping you can learn something from this, and I'm hoping I can get through this without becoming emotional, because it's not always easy. So about 15 months ago, I was having some dizzy spells, and I went to my GP doctor, and I was hoping he would say, oh, you've got low iron, or, irregular heartbeat or something, and thought it would be a simple fix. Well, they kept not finding, and then I got an MRI, and was shocked when the answer was, you have a brain tumor. It's in the worst possible location. For us to get to it, we're going to have to drill from the top to the bottom through very critical infrastructure, and there's a substantial risk that you will not survive. I have 3 kids under 18. That is not an okay thing for me. I'm not ready to leave them. I'm not ready to leave my wife. And they set a date on the calendar, March 7th, and it was 4 weeks out into the future. I know I'm not the only one in this meeting who has had a calendar date which scares the heck out of them. And every day you get a day closer, it's like the doomsday is one day closer. And while I'm naturally optimistic, it was a struggle to stay optimistic. And about 3 days into it, my wife came to me and she said, "We need to talk." And I thought, well, good, because I need some good news because I'm really struggling. And she surprised me. She said, "You're not going to like what I tell you, but we're both aware there's a real good chance you're not waking up. And you're really not going to like this." She said, "You've spent 50 years building the reputation as a nice guy. Everyone knows you as that. But they're not going to remember that. That'll be the second thing they remember. The first thing they're going to remember is what you do the next 4 weeks. If you are negative and you are sad, and we are taking you to Barnes Hospital like a dog going to the vet with your fingers in the car seats, that's going to be remembered. If you are brave and you are optimistic and you are strong, you have the ability to inspire people." And then she said, "And maybe you don't care about what other people think, and that's okay. But your kids need you to do the second. Your kids need you to be strong because this is hard on them, and it's a lot easier if you're leading." And that was it. And so a couple hours later, we did a lot of crying back then. A couple hours later, I got a pad of paper and I started writing down a list of everything I needed to do. And remember, all my documents were fine, but I had a list of over 100 things that I needed to get done because I was going to nail dying. I was going to do the best job of anyone I've ever seen do it because my kids needed it. And I worked on the list over the next 4 weeks. My family helped me. My work crew helped me. And we got it done. And I went in knowing that my family would be all right if something happened. Get through the surgery. Last fall, I was asked to put on a presentation. And at that presentation, I typed up a list. And here it is. And your financial advisor will have this before the end of the day. This is a list, my 100 items summarized down to 40 different things. And if you look, and I know you can't read it, so I'm going to hit the topics. Banking and finance is over here, legal documents, real estate, what you need to be doing with your spouse, if you work for someone else, if you run your own business, medical things only you know. And then I just kind of hit some random other things. Go through it. Once again, it's free. It's easy to do, and you could do it now, and it's going to help them out 5 or 10 years down the road. Just get it done over time. So in preparing for this, I recategorized the list, and I looked at it instead of like medical and financial as to like, what's our legally responsible things to do? That's what we discussed for the last 30 minutes. Your wills, your trust, your beneficiaries. Get those done. Those are easy. But then number 2 and number 3 are things that nobody has in order. Things that are helpful. These are things that I've learned from working with hundreds of families. And I thought I need to do that for my family. And then the last things were the things that you do because you love these people and to give them the easiest handoff possible that no one ever told me, but I discovered it during this time. We're going to hit number 2 and number 3, and then we'll actually be done and be ready for questions. Number 2 is the helpful tasks. Prepare a master list of where all your money is. Often people come to me and say, I didn't know what all banks they were. My wife didn't know that I set up some 529s for the kids. She knew I did it, but I'm the one who handles all that. Leave that, update that regularly. Do you have bank accounts set up for kids? I set up kids' accounts when they were born and put money into it. But what no one tells you is my wife's name was not on the account because I just did it some random day. She gets the statements, everything's fine. But had I died, I'm not sure they would have given her access to those accounts. We may have had to wait till our kids turned 18. So we put a successor adult, her, on those accounts. Your power of attorney, glad you have it. Make sure it'll be listened to. Give it to your financial advisor now. Ask them. I asked mine, hey, if I wake up from this but don't know who I am, do you have everything you need to talk to my wife? Yes, I do. Great. Another burden relieved. Do you own your own business? Work through what happens if you don't come back in. I discovered that when I opened my business 8 years ago, it was just me. I was working out of my kitchen. No one else is listed on my bank accounts. Had I died, well, if I died, it would have been okay. Had I not came back to consciousness, no one is authorized to sign. So I fixed that. Do you work for someone else? Does your family know who to contact at HR? Little things, just do them. Are you someone else's helper? Are you your mom's go-to for her healthcare decisions? If you're gone, is there a backup? Those are things you need to be thinking of. I serve as trustees for families who don't have anyone else to do it. We worked through all those situations to make sure that there was a smooth handoff on those families. Think through it. Now we're up to our last slide. This is the I love you tasks. These are the ones no one told me to do, but they were important. I made sure my financial advisor at Cornerstone freed up 90 to 120 days of cash. I said, I don't want my wife to have to call you and think about this. Have it ready to go for her if I'm dead, if I'm in a nursing home. Set up your auto pay on as many vendors as possible. They don't want to be thinking about this. Number 2 is a tough one. This is where a lot of more tears came in. Ask your spouse, like, what do you need to know if I'm gone? What is it that scares you? What can we do right now? Write those things down. Communicate your end of life issues, not just now, over and over and over, so that it's your decision what happens if you're in a bad condition. Number 4, brainstorm things that only you know, and have a little fun with it. I have kids who think I'm the biggest dork dad in the world, and I love it. And I love when they make fun of me because I know they love me. And I went around the house and videoed myself talking about things that I know that no one else does, right? I did our landscaping. I know where the underground water runoff goes. No one else knows that. I know where the dog fence is buried. I know all these things. I videoed it. My kids have watched it and they think it's hilarious, but it was a good handoff to them also. And lastly, write I love you letters. Early when I did my estate planning career, I had a client who told me the most powerful thing. He said his mom had just died, and when she died, in her packet was I love you letters. He said, I have one from my mom to me when I was 1, when I was 6, when I was 11, when I was 16. She did it all through his life, and he was 40 when she died. Don't get rid of the old letters. Just don't even open them. Just put the next envelope on top of it. And it is, he said, is the most valuable thing. He said, my mom transferred 30 minutes of her time writing a letter into the most valuable thing I own today. I had not done my kids or my wife's. I used my time before the surgery and I wrote them all letters. So that's it. That's what I have. You are welcome to call my office. We are always happy to help. My email's on there. My office phone's on there. And I'll be along as long as Bill needs me.
Scott, that was fantastic. You know, obviously the folks here at Cornerstone have heard your story and you know, kind of lived it with you. And we, of course, were praying and sending all our well wishes your way. But boy, that it's such a powerful story. And I think, as you touched upon, it probably has made you just such a better attorney as it applies to estate planning, because you've lived this, you know, really what is truly important. And it may not be the documents, although the documents are incredibly important. All that other stuff that goes along with it is incredibly important. We are starting to we're starting to compile some questions. And I'm going to read those out to you in just a moment. There were two things that I did want to mention. First of all, I mentioned at the beginning that if you do type in a question down at the bottom, so go down to the bottom of your screen. If you see Q&A, if you click on that, you'll be able to type in a question. That being said, I did say that you would be anonymous. I misspoke. This won't be recorded, but your name will show up, next to the question that you ask. So I apologize to anyone that may have done that thinking they were anonymous. But again, we will read those off in just a second. Second thing I did want to touch on, though, Scott, is you talked about how important it is not just to have the documents, but then also to title the accounts properly. And I know we see that sometimes at Cornerstone, where the client can have this amazing estate plan and these amazing documents drawn up, but then they don't take that next step and title things properly. So number one, I want you to touch on how important it is to include your financial advisor on your estate plan, but then also maybe a couple of mistakes that you see, and specifically how you should title an IRA, maybe versus an individual account, or versus a trust, or not a trust account, but a joint account.
Yep. We see over and over, people did their estate plan years ago and nothing is titled in it. So I tell them, you got this great bucket with great rules and it's empty. I mean, if it's empty, it's doing nothing. So when you choose an estate planning attorney, I'm going to strongly recommend that you ask them, I need you to send the beneficiary designations, my transfer on death listings, directly to the financial advisor. Loop those experts in together. Because if the attorney just gives you the bucket and you're off on your own, the attorney just took your money and didn't help you. So you should have a checklist. Here's what I'm doing on my house. Here's what I'm doing on insurance. Here's what I'm doing in my bank. But let your team work with you like the Cornerstone team will do. The second question is, I like everything going into the bucket, right, as your beneficiary, except for retirement accounts. IRAs, 401ks, those need to, in a traditional marriage, go to your spouse first, and then the trust is contingent. And the reason is your spouse is the only one in the world who can take your inherited account, your IRA, and pretend it was theirs from a tax standpoint. If you send it into the trust, it is a less desirable tax standpoint.
That's great. So, Scott, let's get into the questions. The first one is the TOD whose name, so let's call it the TOD beneficiary, dies before the owner. The TOD or the person it was transferred to, or we'll call it the beneficiary, is married with no children. What happens when the owner dies? The beneficiary has a sibling who is not included on the TOD.
All right, so this is mom's account. One of the kids is deceased. Is that the question?
So one of the kids is listed as a TOD.
Yep.
They're not married, but they do have a sibling who is not listed as the TOD.
Whoever the TOD is in that form gets it. It is a contract with you and the bank, or you and your financial advisor, that overrules everything.
And so if that person who was listed as the TOD is gone, then what happens?
So the form will it'll often ask the question, if this person's deceased, you can say it goes to their kids, or you don't put anything down, and basically it's the same as having no form whatsoever. Now you're going through probate court with the will.
Got it. So you did touch on this in terms of updating your documents probably every 5 to 10 years, or probably if there's a big change in your life, maybe you have a kid, you get a divorce, have a child, get a divorce, any big life-changing events. This question was actually more about if your trust is out of date, can an individual update that or revise that themselves, or do they have to go to an attorney?
Yeah, I would strongly recommend an attorney. You might say I'm biased, but here's what I tell people, and they go, "Oh my gosh, you're right." You may spend $2,000, $3,000, $5,000 a year to insure your house, right? And the risk of your house burning down is tiny, tiny, tiny. But you're happy spending that money each year protected. Well, think of your estate plan the same way. You're going to die. This estate plan is going to go into effect, and if you screw something up, well, it's going to cost a lot more. Go back to my probate fee chart. and it is well worth the money. And I have never seen it go wrong to talk to the attorney.
Well, and you know this better than I do, but you touched on this at the very beginning of the presentation. The laws change. And so if you're just making an amendment yourself and writing it in, you may not necessarily know that what you're doing is maybe obsolete in some way.
Yeah, I got a friend who's an estate planning attorney in Boston, and he jokes and says, I love when people do their own changes. He said, I tell my clients, hey, no big deal. You could pay me $2,000, or when you're dead, your kids can pay me $20. He goes, I'm fine either way. And he's joking, but he's also sincere because we do see it.
No doubt. So this is a question about a revocable trust. And I think this really probably comes down more so to the titling, but it says, I have a revocable trust now. Does it automatically place a TOD on everything?
No. Your trust is your bucket. It has great rules, but all those assets you own have to find their own way to the bucket through your agreement with your bank. Hey, bank, it needs to go to the bucket. Hey, LPL needs to go to the bucket. The bucket does not have hands to reach up and grab things. The biggest problem is homes. I will see attorneys that will write in the trust, I hereby transfer my home into the trust. Well, you really didn't do anything because homes transfer by deeds. Deeds must be filed or they're not going to be effective. And so that attorney just gave the client a false sense of security that everything's covered. Got to file that deed, got to move it to the bucket.
We've had a number of questions on, will there be a recording, or some people came in late. The answer is yes, this is recorded. The process for that is this recording will have to go through compliance. Once it's approved by compliance, we will then make it available to your financial advisor, and then they can send it out to you. But again, you will have access to the presentation via the recording once it's available. There's a question in here, or a request to go over Form 706 again. Could you explain that process and what it does?
You bet. Form 706 is your notification to the IRS. It's called an estate tax form. And you may call your CPA and they go, you don't need to file that, because the CPAs are going to think it is a form that's only due if you owe estate taxes. But there's another purpose of it that CPAs don't think about, and it is, hey, your spouse died. Your spouse could have passed 13 million to the kids and passed 0 because everything went to you. So he or she has an exemption amount, which is going to go away in 9 months, or it could be moved to you to be put into your pocket to be used when you die, added to whatever the law is. 706, when you don't owe, and I don't know anybody who owes on it, is an informational return. Must be filed. As I said, 9 months. You can get an extension. Don't get extensions from the IRS. It's not worth it. And I've told people to do it. They go to their CPA and goes, oh, she said I don't need to file it. Baloney, file it.
Here's a request from a potential new client. Are you able to work with people living in a different state from you?
Missouri and Illinois are the only states I'm licensed in. But feel free to reach out to me. I know attorneys in other states, and I could send you to somebody who would be better than Googling it.
So here's one kind of the softer side of estate planning. Do you have a recommendation of how to start having the conversation with aging parents or aging in-laws about estate planning?
Boy, I guess that's the toughest question today, isn't it? Sometimes they don't want to pay for it. And I had kids tell their mom and dad before, like, hey, this is free. And then as it goes along, the kids pay and I, disclose that to the clients. But sometimes that's it. But I don't have any great recommendations on it. I wish I did. Maybe your financial advisor may have a better idea on that too.
Yeah, that's a good point. So this is one, I think, again, this gets back to the question before of, can you work with people in other states, but kind of framed a different way. Our trusts, wills, powers of attorney, are they effective in other states? So let's say I get my trust done in Missouri and I move to California. What are the ramifications of that? Is my document still valid? Yeah,
great question. if it was valid when you signed it, so you're a Missouri resident doing a Missouri trust, it's valid in all 50 states. Now, you go overseas, all bets off, no idea, but it is valid in all 50 states. And is it a best practice to update it when you move to another state? Yes, it is, but I'm inherently thrifty. And so I tell people, look, if your first marriage, all joint kids, and you guys are younger, I wouldn't waste my money because the odds of this kicking in are very low and it's going to work. Now, if you're 90 years old and move to another state, I think I'd have it looked at because the odds of it kicking in are higher. And there may be some nuances in that state, but I think your need to do it is low, but if you want to be safe, you can.
Scott, here's another tough question. So we got a question about mother is incapacitated, it has signs of dementia. The person who's been named to manage the trust is mismanaging the trust. How should, say, a child, a relative, how should someone go about getting that person removed from the trust who's mismanaging it?
Yeah, your best friend as you age is your financial advisor. I'm not saying this because Cornerstone's asking me to do this event. It's real. And my clients come in, sometimes I might have 200,000 with Cornerstone and $1 million that they invest on their own. As they get older, move that to someone who cares about you and knows your family, because they can intervene and do some things to help. Now, legally, if that child is mismanaging the money, and I've seen that happen, they're committing a crime. It is against the law. That is mom and dad's money. It is mom and dad's bucket. It's to be used for them, not for you to take a trip. And the law can get involved, but it tears families apart. So two things: one, pick a good financial advisor you trust. They're your cop. And two, choose a kid who's not going to do that. And if you think they will, don't pick them or make them have a co-trustee. You can put two people have to agree on everything.
This might get more so into elder care and maybe how you structure things for a spouse who might be going into a nursing home. But the question is, can you speak to how to best protect a surviving spouse's monies if the other spouse goes into a private pay nursing home? We have extensive monies, but if my husband goes into a nursing home and it costs $7,000 a month, that can start to go pretty quickly. So are there things that people can do structurally to maybe protect assets for that spouse who is not going into the nursing home?
Yep, you bet. There are often things clients bring to us, and then when the reality of the situation is told to them, they don't like what they have to do. Because back to my bucket, a normal bucket is, it has no lid on it. You have both spouses holding the handle of that bucket. They can reach in and pull money out. To protect it from a nursing home, and I'm only speaking to Missouri, but I do know the laws are very similar in other states. You have to set up another bucket, move some assets in it, put a lid on it. You're no longer controlling it and moving it away. And you basically say, hey, this isn't mine anymore. And maybe the kids manage it, but legally it's not yours. And you have to do that 5 years before you need to go into a nursing home or need the government money. And then the government looks at it as if it's not yours. Now, that's where I'd work with my financial advisor. Maybe long-term care insurance would buy you that 5-year buffer. I often have people who have a lot of money. They'll have $3 million and they come to me with those concerns. And I say, let's work through this. Your financial advisor can make you 5 or 6% a year. You have $3 million. You have $180,000 a year coming in. Let's not worry about the $7,000 a month because it's better to private pay than it is to go in the government one. So that puts concerns to rest.
Sure. I had a question about what's the average cost to set up a trust?
Yeah, we are anywhere from probably $3,000 to $4,000 for a normal trust. There are some people who charge twice what I do, and they're busy. I'm busy, so I think we're on the low end, but I would think probably $3,000 to $5,000.
And then some questions about tax advantages of wills versus trust versus wills. I guess probably a lot of that comes into how much you have. But are there, in terms of just normal situation, assets passing from one generation to the next, are there any tax advantages of one versus the other?
There's really not, if you go back to my drawings with the arrows, if you send everything to your kids, they're going to pay the taxes on it at their rate, income taxes that it grows to. If you send it into the bucket and you hold it there and do not distribute it to the kids, well, then the bucket's going to need to file its own tax returns. It's a taxable entity. It does pay a higher rate, which people don't like, but then your bucket's still able to manage it. But if your bucket earns income and distributes that to the kids, it gets taxed at their rate. So the simple answer is there's not that much difference unless your bucket is the one with the lid on it given away. It will pay a higher rate, but that's okay because you're protecting it. It's worth that additional cost. But those are things that just get balanced out.
So Scott, I'm gonna give you a couple more here, and then we'll wrap up. We've had a few more questions come in about properly registering the accounts, funding the trust, however you want to call that. And I think there was maybe a little bit of confusion of, okay, why should I name a person as a beneficiary on a retirement account as the primary beneficiary, and then the trust as the contingent or secondary beneficiary? And then some other questions, which I can answer this one, can you name the trust on an account that's already been established prior to the trust? The answer is, of course, yes, you can retitle it. But, again, maybe could you just clarify again what should be titled in the trust, investment accounts that should be titled in the trust, and then what maybe should, or a reason why that retirement account would not be titled in the trust, or not titled, but the beneficiary wouldn't be the trust?
Yeah, so a lot of attorneys tell their clients when they set this up to move the house into the trust, move their accounts into the trust, move their bank into the trust. We tell them take the simpler approach, leave it in your name, just make a transfer on death to that trust, right? It's the difference between you holding the asset and tying that arrow to the bucket, or you moving it into the bucket right now. Either way is fine with every asset you own, except retirement accounts. And the only reason is retirement accounts are the one thing you own. Nothing else that you've never paid taxes on. Everything else you've paid taxes on. You pay taxes on the money you made to pay for your house, but you have not paid taxes on the money that's in your traditional IRA. And so we do have tax concerns. Your spouse gets better tax treatment than everyone else in the world. So you name your spouse, and then you name the trust as contingent.
Yeah, and let's just clarify that for everyone. Everyone, we're talking about retirement accounts. So that's IRAs, that's 401ks, 403bs, even pensions, things of that nature where you get to name a beneficiary. So again, you're going to name a spouse or a person as that primary, and then you're going to name the trust as the contingent.
Yep.
Last question here from the attendees today. What happens if your lawyer passes before you do? Do you have to pay to have your estate plan done all over again?
Are they asking that because they think I'm going to be dead? So no, it's a great question. I've always told my clients the least important person in your estate plan is me. I do this so that I'm unimportant. I do this so that if I die the next day, another attorney can help you. It's what we're doing is common across the industry. And so, just like if your financial advisor dies, you're not in trouble. You got to find a new one. Same thing with you. Years and years and years. I lost a video.
Scott,
you lost me for a second, didn't you?
Sure enough, I did jinx you.
I'm glad it happened now. No, so basically the attorney is very unimportant. Now, some attorneys will write themselves in and say, it's baloney. Don't let your attorney write themselves into the document. It's a way for them to make more money in the future. If they're good at what they do, they don't need to hustle you to come back to them. And so it doesn't matter if I'm dead. It works just fine.
That's great. Well, Scott, this has been fantastic. I know I've learned a few things. With all the questions we've had, I know everybody has learned a lot from this. I would just say one last thing, and I think you did a great job of touching on what I would call the softer side of estate planning. And, the other part of this that I always go back to is it's so important for the individual to spell out what they want to have happen, and then probably also communicate what they want to have happen along the way. And beyond how money transfers, beyond taxes, which are all very important things, it probably keeps the family from arguing. Yeah. Because it's already spelled out. This is what mom and dad wanted. And so it keeps that family from falling apart after you're gone, which is probably the thing that you want least to happen.
It is a huge gift. There's no other way to put it. Back to, can you do this on your own? You absolutely can, but this is going to go into effect one day. Unlike likely your car, house insurance will probably, hopefully never be used. This is going to be used, and you can make it a lot easier for them. Hey, Bill, I got one more thing.
Yeah. I
will have to Cornerstone before the end of the day a PDF of that sheet of 40 things. So Cornerstone, I would think we'll forward it to your financial advisor, and so you can get it.
That's fantastic, Scott. Again, appreciate your time today. Appreciate everything you shared. And again, for everyone who is still on, if you missed it, if you came in late, if you want to share this with a spouse, we will be getting this recorded. Will take a few days for us to get it approved by compliance, but we will have this available through your financial advisor, where they can send the link out to you and you can share it with family, share it with friends, and they can learn from this as well.
Thank you very much. Appreciate it.
Thank you, Scott.
Bye-bye.